Hola! Good morning, classmates. Good morning, Prof. Kate. We are from Group 9, Team Active. Our topic for today is about extrajudicial settlement of estate. So before we proceed to the lesson proper, let me introduce to you our team members, the Team Active group, Mr. Dennis Mila, Ms. Chelsea Ladaga, Ms. Jeneline Lachica, Ms. Jessa Basha, Ms. Jenny Medina, and yours truly, Ms. Maricel Valente. Settlement of an estate need not undergo judicial proceedings all the time. Under Rule 74, Section 1 of the Rules of Court, it allows the extrajudicial settlement of estate by agreement among the heirs. It says here that if the decedent left no will and no debts and the heirs are all of age, or the minors are represented by their judicial or legal representatives duly authorized for the purpose, the parties may, without securing letters of administration, divide the estate among themselves as they see fit by means of a public instrument filed in the office of the Register of Deeds. And should they disagree, they may do so in a ordinary action of partition. If there is only one heir, he may adjudicate himself the entire estate by means of an affidavit filed in the office of the Register of Deeds. The parties to an extrajudicial settlement, whether by public instrument or by stipulation in a pending action for partition, or the sole heir who adjudicates the entire estate to himself by means of an affidavit, shall file simultaneously with and as a condition precedent to the filing of the public instrument, or a stipulation in the action for partition of the affidavit in the office of the Register of Deeds, a bond with the said Register of Deeds in an amount equivalent to the value of the personal property involved as certified to under oath by the parties concerned and conditioned upon the payment of any just claim that may be filed under Section 4 of this rule. It shall be presumed that no debts if no creditor files a petition for letters of administration within 2 years after the death of the decedent. So to know more about the Rule 74 of Section 1 of the Rules of Court, here are some of the definition of terms. Extrajudicial settlement of estate is a private agreement between the heirs of the deceased person which sets out how the estate of the deceased will be divided or distributed among themselves. So the term of the private agreement to settle the estate of the deceased are set out in a document called Deed of Extrajudicial Settlement of Estate. What is meant by extrajudicial? It as opposed to judicial, in the sense that the heirs do not go to court to settle the estate. So the term estate, it is the collective term for the real and or personal properties left by the deceased person or decedent. When you say real property, it cannot be moved and is anything that is attached to land. Real properties like family home, condominiums, or land titles. For the personal property naman, this property are those anything you can move and is subject to ownership except land. Okay, so how about what if there is only one surviving heir? If there is only one surviving heir, he may execute an affidavit of self-adjudication, which adjudicates the entire estate to him or herself. So what are the steps involved in transferring the title of the properties to the surviving heir or heirs? So we have two. First is settlement of the estate taxes with the Bureau of Internal Revenue. And then the second one is the registration of the transfer with the Register of Deeds where the property is situated. So these are the documents needed for the settlement of estate. First is the notice of death. Second, certified true copy of the certificate of death. Deed of extrajudicial settlement of the estate. Certified true copy of the land titles involved. certified true copy of the latest tax declaration of real properties at the time of death, statement of a certified public accountant on the assets of the decedent. And the last one is the certification from the barangay captain in cases of real property claimed to be a family home. If there are personal properties, you need also to they are also requiring these documents, the copy of certificate of registration of vehicles, if any, and other proof showing their true value. Then the second one is the copy of certificate of stocks, if any, proof of valuation of shares of stocks, whether listed or unlisted at the time of death. And the last one is the proof of valuation of other types of personal property. So we will now go to case study. Our case study is the extrajudicial settlement of the estate of the deceased Marvin S. Yumol with 7 deeds of absolute sale and waiver of rights. So these are the facts. Mr. Arvin S. Yumol died in Korea on July 15, 2017. The cause of death is myocardial infarction. He is married to Miss Maria Rowena Yumol and they don't have children. Their residence address is at 58 R. Gonzales Street, BF Homes, Parañaque City. The decedent or Mr. Yumol died without intestate or wala siyang last will and testament. So the heirs, Ms. Maria Rowena Yumol as the living spouse, and also the 4 siblings, Ms. Maylin Yumol Espina, Mr. Paul Yumol, Mr. Angel Brian Yumol, and Ms. Giselle Yumol. So they have, at the time of death, Mr. Yumol left behind the following properties. So BF Homes property, as it is their family home, with considerable amount of the properties listed, Ms. Rowena sells, transfers, and conveys all her rights and interest in favor of the 4 siblings, free from all liens and encumbrances, except the restriction provided in Section 4, Rule of 74. Mr. Arvin and Ms. Rowena have one community property. It is the second lien property. So Mr. Angel Brian is a co-owner of the said property. So Ms. Rowena waived her rights on the said property as Mr. Angel Brian accepted it and received it. So these are also the personal properties of Mr. Arvin Yumol, the 2013 Toyota Fortuner, and the 2 pistol. All 4 siblings, out of liberality, waived their rights for personal properties of Mr. Yumol to Ms. Rowena Yumol. She fully accepts and receives the waiver made in her favor. So this is the copy of extrajudicial settlement of estate of Mr. Arvin Yumol. This is a legal document specifying the compliance with the legal conditions for an extrajudicial settlement, the description of the properties to be extrajudicially settled, like the title number, value, location, lot size, and technical description. It also has the nature of the property, if it is conjugal property, the name of the heirs, how the properties shall be divided among the heirs, posting of a bond if there is a personal property involved, and also undertaking the deed will be published in a newspaper of general circulation once a week for 3 consecutive weeks. So to discuss more of the case, let's move on to the Trinity. So the first one is legal. These are the legal matters that needs to settle. First is the conditions in order for extrajudicial settlement of estate to be allowed. Second is the qualified heirs. So the conditions is, first is the decedent died intestate. So Mr. Yumol doesn't have last will and testament. The decedent also has no debts, and the heirs are all of legal age. A debtor condition is a public instrument wherein it is duly executed by the heir or heirs filed with the Register of Deeds. So for the qualified heirs, in this case, the qualified heirs is the surviving spouse since they don't have children, and four siblings since most of the properties are also under their name. Okay, for the technical side, this case is not hard to process since all the acquired properties are all titled. And also the personal properties given, like the Fortuner, the pistol, they have license too and registration. And for the financial, it is the main concern here because of the basis of the computation of estate tax. For the discussion of the case on the estate taxes, deduction and procedure to be discussed is relevant only to those who died before January 1, 2018, since Republic Act number 1096 or the Train Law amended the tax code, including the procedure, tax rates, and deductions for estate taxes. So the Train Law became effective January 1, 2018, which our case kasi hindi siya pumasok doon. Okay? So the basis for the computation of estate tax. So before filing the extrajudicial settlement with the Register of Deeds where the land is located, it is necessary that the estate taxes be paid first. So according to the BIR, estate tax is not a tax on property but rather imposed on the privilege of transmitting property upon the death of the owner. It bears great emphasis that the estate tax return must be filed within 6 months from the decedent's death. The deadline may be extended by the commissioner of the BIR in meritorious cases, but not exceeding 30 days. So in this case, the date of death of decedent was July 15, 2017. The estate tax return was due on January 11, 2018. It was filed 9 months after the due date, so there was an interest incurred. So for the basis of computation, the estate tax is based on the value of the net estate. As computed by the ONET or the one-time transaction team, the net estate value of Mr. Yumul is more than 10 million. So automatically, there is already 1,215,000 tax plus 20% on the excess of 10 million. So this is the summary of RA 8424. Ito yung naging basis noong case ng extrajudicial settlement ni Mr. Arvin Yumul. So the total area, the total real properties of Mr. Arvin Yumul is 16 million plus personal property of 321,569 pesos. So there are allowable deductions on the estate. These deductions include funeral expenses, share of the surviving spouse, medical expenses incurred by the decedent within 1 year prior to his death, family home deduction of not more than 1 million, standard deduction of 1 million, among others. So the net value of the estate to be inherited is valued at 13.9 million. So based on the estate tax rate, the tax shall be 1,215,000 plus 796,400. It is the 20% of the excess of 10 million, which totals 2,011,000. Since they pay it 9 months after the due date, a 25% surcharge and an interest as counted from January 11 to October 23, 2018, and a compromise penalty, it has a total amount payable of 2,868,000. So, sobrang laki ng penalty. Okay? Almost, almost 1 million yung penalty. So, after the estate have been paid, the heirs may proceed to the Register of Deeds where the land is situated. The Register of Deeds would allow it the filing with the BIR and the Register of Deeds may be simultaneous. The proof of payment of the tax estate, affidavit of publication of the deed, the extrajudicial settlement of estate are the basic requirements to be submitted to the Register of Deeds. When all pertinent documents are submitted, the Register of Deeds will correspondingly issue a transfer of certificate of title to the proper heirs. So that's all. That will be our report for extrajudicial settlement. Thank you.